Good, 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 good. Welcome back, welcome back. Hope you have a nice day. Let's see. What day is today? You want to see a shirt? I like that. It's good. Do you have any days of the week shirts, or is that the only one?
The only one.
Did you have like a Garfield like I Hate Monday shirt? Someone will wear that Monday again. What's that? All right. Let's see. Anyone do anything fun yesterday? Anything interesting pop recently? No, not on Tuesday. All right, everyone. Shh. Okay. All right. So we are continuing our study of estates. Okay. We're gonna be on this topic for quite a while. So hopefully everyone heeded my admonition and really focus on the notes from the last class, because we will be building upon that. And if you can get last class, this class will make even less sense. Okay. So questions about what we did last week? Anything on your class? Anything on your mind? No? Okay. So let's do a little mini review, and now we will put us in a better spot to move forward. So we introduced, okay? And again, the word estate means what you think it means when grandma died, she left me her estate, right? Estate refers to relations between a person and a piece of land. And specific estate answers to who owns it and when do they own it. So whenever I ask what is I'm really asking you to tell me, who owns it and when they own it. One of the first estates we studied, something called fee simple, which was the most simple of all, and is that a person owns a piece of land, else has a superior claim to it, simple means. Okay. So when I say that, A owns Blackgate fee simple, I mean A owns it forever. And we use certain magic words to designate fee simple. You'll know this because it's like to A and his heirs. Right? When you see this phrase "and his heirs," this should flash a light in your head to say, okay, this means fee simple. I usually don't like memorization. I don't care for memorization, but there's no way around it. There's certain words that have been used in this context for like 500 years to mean fee simple. So you're going to need to memorize or put in your notes or do something to remember. When you see "and his heirs," you translate that to fee simple.
Is that going to get more complex whenever
yes.
it starts to his heirs and
yes.
of his body?
Well, we're not doing Feetail. We'll do Feetail, but yes, it does get more complex. Okay. All right. So you're going to have to memorize, or at least keep a list of all the different magic words I like to call them. Okay. The difficulty of this topic is that you're dealing with complicated relationships, and you need to be fluent, right? You need to be able to say something that I own something forever. Okay, that means fee simple. That means and his heirs. Usually, very fluently. All right. Questions in that? That's like the summary of last class fairly quickly. Okay. So we also said last class that, of course, it's impossible for one person to live forever, right? Like Drake said, you only live once. So no one can live forever. No? No, yo. Did you not get that the first time? Oh, man. Oh, there it is. Okay. You can't live forever, right? So invariably when, A dies, right? When to A and his heirs, right? So when A dies, what happens? Well, the land doesn't just disappear, or the land doesn't belong to no one. It goes on to A's heirs. And as we said in the last class, A can designate who his heirs are. That doesn't necessarily mean his children. That doesn't mean his wife. Doesn't mean his husband. Whatever. He can designate who his heirs are. Okay, that's the modern approach. Way back common law, primogeniture applied, and you can only leave it to your firstborn male son. That has not been the law in this country for over 2 centuries, so that's not really a concern for us today. Okay. Everyone get the idea of fee simple? Okay. Any questions on that? This is the easiest one. It gets much worse next week. Today's actually not too bad. All right. Okay, good. So the book has a little bit of a discussion of how you inherit a fee simple estate. Okay? And again, this phrase, and his heirs, is a very powerful phrase because it signifies that the person who owns it can decide who gets it when he dies. He can sell it during life, or he can specify things. Historically, the main way by which property was transferred was through someone's heirs. Okay. Now, we said this last class, heirs are not calculated until the time of death, right? So we don't know who A's heirs are until A dies. So it's often missaid, like, that Paris Hilton is an heiress of her parents. I don't mean to pick on her, but she's a famous heiress. That's not true. You only become an heir when the person dies, right? No one is an heir of a living person. Remember that. No one is the heir of a living person. This will trip you up on questions if you ever try and say that, oh yeah, so-and-so is an heir of this person, even though the person hasn't died yet. So remember, no one is the heir of a living person.
They're an heir of parent. Right?
That's not a legal term, really. I mean, it's a hypothetical, right? I mean, you may be an heir, you may not be. It's not calculated until the person dies, right? I mean, that's a phrase that's often thrown around, but it doesn't really have any legal significance, right? You can't get a mortgage on something or get a loan based on security of being an heir apparent because it's not as certain. It's not certain to accrue. Okay. All right, any questions on that? All right. The book also defines this term kin. Kin basically means some sort of family member. It's a fairly broad term, but it focuses on personal property, not real property. Okay? So say you have like a car or an expensive painting or something. The person who inherits that will be called kin. It's the phrase is not too important to distinguish. Okay? The other phrase which they discuss is something called dying intestate. Intestate. Where did I finish last time? I think I went somewhere there-ish. Yeah, I think. All right, Andrew, you're up. What does it mean to die intestate?
It's just before you, like, if you don't have a will written or if your will is like voided for some reason.
Exactly. Right. So intestate means when a person dies without a will, or if you have a will and the will's void. Say it doesn't have the correct number of signatures, say they didn't have enough witnesses, say it didn't comply with all the formalities, right? So generally speaking, if a person dies without a will, there's a very complicated set of formulas to determine, okay? Yeah. There's a very complicated set of formulas to determine who gets what. And I'll try to walk you through some of these examples. You will do this in your wills and trust class, but you get a little preview here today, and maybe you'll remember it for next year. Okay? So the general rule today, right? A focus on whether there's a spouse or children. Okay? So let's assume for a moment that there's a spouse, right? Usually the spouse gets half, and and the children get maybe a third apiece. So basically split up the rest. So usually the spouse will get half, and then the children will basically split the other half or something like that. It varies wildly, and the actual specifics aren't so important. But the key thing to remember is that even if you don't have a will, your family will be somewhat taken care of. Okay? Now, almost everyone dies with some heirs. Okay? Almost everyone dies with some heirs. Most people have issue. The word issue generally means descendant, but it can also mean children. But you can, if needed, go very far to find any issue. Okay? There was actually a story mentioned in a footnote. I don't know if anyone read it. There was a Holocaust survivor, actually from Staten Island, where I'm from. He died sometime in his 90s with no will. He was a multimillionaire. He had no heirs. He had outlived everyone in his family. And because he survived the Holocaust, most of his family was exterminated. So they have no one to give the money to. and they've been trying for, I think, now almost 2 years to try to locate any heirs anywhere in the world. And of course, when there's millions of dollars, we had old people come forward like, oh, Uncle Shlomo, whatever, right? No, they always come forward and they try and find, some heirs, but they haven't found anyone. Okay. So, Aaron, what happens if a person truly dies with no heirs, no issue, they can't find anyone anywhere? Good. Yes. Okay. So there's this phrase. I've heard it pronounced different ways. You said a sheep, which is fine. I've heard other people say eshiat. I say it both ways, depending on what I feel like. When a person dies with no heirs, and I mean no heirs, you can't find anyone, like that guy from Staten Island, the money actually reverts to the state. I'm sorry, the land reverts to the state. Works for money also, but for our purposes, land. This is very rare. It's usually rare for one reason. If someone has that much money, they're usually plan enough to make sure that it goes somewhere, right? The case where a person dies with enough money or land for it to matter and no will, I mean, your rare case. Okay? For whatever reason, law students love the eshiat. They always say, oh, what if the person dies with no heirs, okay? So I'll make this really easy for you. On the exam, it'll be really clear if a person has no heirs, right? It'll be really, really clear. That's probably not going to be the answer. Okay, that's going to be the answer if it's very abundantly clear there's no heirs left. Okay, for whatever reason, I always hear people say, "Oh, it eshiats," which is like the shortcut saying, "I don't know where it goes." But I think that's actually the reason why, but I haven't figured it out. So the issue is an answer that a human being inherits it, not the state. Okay. Let's see. All right. All right. Let's take a look on page 221. I'll walk you through a sample inheritance problem. Question number 1, and I'll walk you through this just so you get a sense of how this works. Okay. All right. Could you read it, please, Jordan? Mm-hmm. Okay. Yeah. Keep going. Yeah. Okay. Okay, so the 1800 one is actually fairly easy. Okay. The reason why the question about who owns an 1800 is easy is because of primogenitor. So the general rule back in the time of primogenitor is that spouses take nothing. The only person who takes something is the firstborn male. Okay? But what happens here, right? Where B is the firstborn male and he dies. What gets funky is that B's firstborn male takes it. Ah. So what happened here is that O was the father. He had 2 children, A and B. The son dies, right? The son left all the property to his wife. But the son had another son. The grandson gets it. He goes to primogenitor. The grandson takes everything. It's kind of a weird result. So at common law, the wife is totally cut out, even though the money was left to her, and the son takes it. Everyone see that? It's kind of a weird result, yeah.
I'm confused with it being under modern American law.
I'm talking, no, it's 1800 in England. I didn't get to modern yet.
Oh, okay.
Yeah, I was talking about in England in 1800. I'll do the next one now? Yeah. So the modern one actually is a little bit more tricky. The modern one's a little bit more tricky. And this is probably going to make you might seem a little bit unfair. But think about it. Heirs are determined by bloodline, right? Alex, is the wife at all related to O? The wife is not related to O. Okay? Alex, let me ask you this question. When the son died, when B died, was the father still alive? Yeah, so let's get the sequence right? First the son dies, and in his will he leaves all of his property, everything, to his wife, right? And then the father dies, right? Alex, at the time B dies, did he have any claim to O's land? No. Everyone see this? Why, Alex? Exactly. Until O dies, he has no heirs. So this was the question someone asked before. Even though B gave whatever interest to his wife, they weren't his yet. There's no heir apparent status, right? You can't devise. Devise means give. You can't give a claim on something you don't own yet. So until O dies, B had no claim to it. So as if this entire transaction to the wife made no sense. So when O dies without a will, you follow the bloodline. And the wife, I hope not, is not related to O. I mean, it's possible that the wife is also his daughter, but that would be really odd, right? It's all relative, I guess. So there it is. You got it.
Oh, that was good.
It was good. There it is. Okay. I'll see you time to think. Okay. So actually, what ends up happening is the only people who take, right? The only people who take are the blood relatives, right? And who are the blood relatives here? I guess Justin. Who are the blood relatives that are still alive at this time?
What are the kids?
Well, the daughter, right?
Yeah.
And then who else? Who else is a blood relative that's alive?
The son and the daughter.
I'm sorry?
B1, B2, B3?
Exactly, right? So who's alive? There are 4 people that are alive, right? There's the daughter, A, and then 3 children, B1, B2, B3. Okay, so how do they split it up? I'm sorry? A1, yes. Yes. I'm sorry. So there are. Yes. That's right. Okay, so A1. Yeah. So you have. Yeah. You have A. Yes. You have A. I'm sorry. You're right. You have A1. You have A. You have A1, and you have B1, B2, B3. Okay. So effectively, we have to think about this like tiers, right? There is one. Let's call it a daughter, and then 4 grandchildren, right? Right. So let's work this out. Okay. You have so you have 1 daughter, and you have 4 grandchildren. So the way the statute works is that depending which tier of family you're in, you get a different cut. So in this case, the daughter would get half. And then the 4 grandchildren would split 1/2. Yeah.
There's 2 children, A and B, but one of the grandchildren is A.
B's dead.
Right, but there's 3 grandchildren from B. Wouldn't they split to half, and the grandchild from A1 doesn't get anything until A dies?
Wait a minute. You know what I think happened here? Okay, I know what happened here. So you have a new edition of the book. They actually changed the question. I didn't even realize it. Okay. In the old edition of the book, A didn't have a son. Okay. So let me take this step back. Yeah. They're getting trickier on me too. Okay. No, you're right then. So actually, we have a situation where there are 3 children from B, and then A has 1 child. So what ended up happening is that let me start over again. I'm sorry about this. They changed the question. I didn't realize it. They modified it slightly. Okay. So A and A child, they would split that. They would split their half, right? And then B1, B2, and B3 would split a half. And if you want to do some math, they would just get 1/6. Yeah, that's it. I realized about halfway through they changed the question. I had to do it in my head on the fly, which is not always the best thing. Yeah. I'll make a note for next time I teach us that they mix it up. It's really weird. I mean, this is something which I don't know if you appreciate, but there's a serious racket about textbooks. And I don't use this word lightly. They update the textbooks every 2.5 years. And they literally change from one edition to the next 5 or 6 cases. And this isn't a case like constitutional law where you have like new Supreme Court cases that you need to. Property's been the same for like 1,000 years, right? I'm not exaggerating much. So they make very subtle changes, like they add a sentence here and there, and it's not always abundantly clear where sentences are changed. So I apologize. I should have checked that closure, but I didn't even notice. Yeah, Ashley.
A wouldn't get a portion until, or A1 wouldn't get a portion until A passed away. Is that correct, or are they splitting it? From the
Well, so what happens? Yeah. So what ends up happening is because because A is still alive, A would get all of it, but effectively there would be a share somewhere down the road for A1. Yeah. Yeah. So I mean that's basically it. It's more or less A1 won't inherit immediately because A is still alive, but presumably A1 will get a cut from when A dies, whenever that happens. Yeah.
Does they automatically get it, or does A have to?
Well, what's interesting is A could then cut out of the will her child, which is possible, unless she dies intestate also. Okay. So really, if you want to be precise, right? At the time of O's death, A gets the half herself. Everyone see that? A gets the half herself. At some point in the future, then they will probably end up splitting that half. Okay, everyone see that? Yeah.
So if B1, B2, and B3 are splitting half because they're representing B.
Yes. Yeah, that's a good way of looking at it. Yeah.
If A had passed away also, so then it would be split 4 ways between B1, B2, B3, or half.
Okay, so let me answer your question. So let's say let's do another hypothetical, right? Let's say that A and B are both dead, right? Is that your question? Okay. So what's interesting is that A1, right, would get her mother's share, which would be half, and then B1, B2, and B3, they would split B's share, and they each get a 6. Everyone see that? That's an even better question. That's probably should have framed it. The fact that A is still alive means the kid doesn't really get anything now. She has probably some share in the future from the world to come, so to speak, but nothing at the moment. Everyone see that? This splitting. There's a phrase. It's called per stirpes. P-E-R-S-T-I-R-P-E-S. It means basically per stripes or like per family member, and they chop it up based on the number of family members in a given bloodline. Okay. Yeah.
I'm sorry. So does the wife of O have rights?
The wife of O or the wife of who?
Oh, wife of O.
There is no wife of O in the question. Yeah, it's B's wife. There is no. I mean, there might be a wife of O, but that's not in the question. But generally speaking, your wife gets because you are married to her. So if O had a wife, his wife would take probably a half, and then the kiddies would split the rest. But in this question, there is no wife.
Thank you.
You can see why wills and trusts gets very messy, really messy very quickly, because you have all these eventualities, all these different family members. Yeah.
B's wife gets nothing because
Zip.
she's not a
Blood. She gets zip. B's wife gets nothing, but the point I want to stress is the time that B divides all of his property to his wife, B hadn't inherited anything because O was still alive. You don't become an heir until the person dies. See, it looks like such a simple question, right? And it gets really messy. This is why you need a trust lawyer, a wills and trust lawyer, if you have any deaths and property. Yes, ma'am.
Okay. Can you put your survey stuff on the board? I asked you about yesterday and you said we're not going to do that.
I don't think. No. What'd you ask me? I don't think you asked for stirpies. Okay.
Because yesterday you said that if the receiver dies before meeting that
What did I don't remember what it said. What did it say?
I don't know. All I remember is you said that's not going to be used. That's only for people.
I think you may have asked me something else. I don't think I. Okay.
Let's just say we weren't going to use Feetail.
Well, we're not using
Yeah,
Feetail.
that's the only-
That's what I thought you asked me. Per stirpies has nothing to do with Feetail. Yeah, I mean the Feetail I put in the brief to skim it because it's not too important. I thought that's what you asked me. I don't think I said anything about per stirpies. Per stirpies has nothing to do with A Feetail. For Serpy simply means if you have 3 children and each have to inherit, they split the same share. That's all it means. There's nothing to do with Feetail. Sorry, no gotcha there. All right, what else? Yeah.
I don't know how to frame this question, but the descendants are always going to be like the first one's always going to be the children, like the issue, right? And then it will be the wife, and it not will be the parents of the person who died.
Basically, yeah. There's a complicated formula, and I don't want to go through the details, but you usually start with a person's spouse and their blood children, right?
Okay.
And then you go to the children of their children, right? And then if there are none of those, you go to brothers or sisters, right? And then you might maybe go to parents, right? It's a very elaborate.
For example, in this case, let's say the D died intestate, like he didn't devise any of his property to his wife. Once O dies, B's wife would also get a half share of that.
No.
She wouldn't?
No, she won't, because the
I'm sorry, no,
yeah,
right.
B
Yeah,
can't divide.
yeah.
Right, B can't divide something until he gets it. Right, I can write a will saying I leave you all $1 million. If I don't have $1 million, that will's worthless, right? You can't. You can put whatever you want in your will, and maybe in 20 years, longer, maybe in 6 years when I die, right, I might have that money be paid out. If I don't have it when I die, it's irrelevant. Right, there's often a problem where people will write wills and they'll put something there that maybe they have, and by the time they die, they don't have it anymore, and then it's like, too bad. You can't distribute something that you don't own anymore. All right. Other questions? Yeah.
Does the splitting go all the way down?
Yeah.
If B3 had 2 children, she dies before O, does her 1/6 then go to her children?
Yeah, then it gets split into 12ths. It gets really, I don't want to burden you with math too much, but this gets really messy really quickly. You might have to do something like this. I'm glad you think so. Right, but something along these lines would be in the ballpark what I would ask. All right, one at a time. Any questions? Yeah. All right. Any other questions on this? Yeah.
If B died, so the hypo was before O. If he died before O, would his great grandkids be there?
Well, B did die before O in this question.
So it's like if B3 died.
Yes.
She had children.
Right. So yes. So his question, let me answer. I'll get back to yours in a second. Right. So say B3 died. Right. The 1/6 that would have gone to B3 would then be split to her children. Right. So say B3 had 2 children, they would take the 1/6 share and make it 1/12 and 1/12.
What if she doesn't?
If she has, no, it's heirs. It's not just. Enough. I don't mean to stop, but this is why wills and trusts gets very messy. Virtually everyone has heirs. Remember I said 15 minutes ago people love asking what if someone has no heirs? This virtually never happens. Everyone always has some heirs. You find cousins, you find this, you find that. You'll eventually find an heir somewhere if it's worth the money. For some reason, people love the eshiat. They always hope at eshiats. Yeah.
So this is all if the person dies contesting, right?
Yes. Exactly.
If there is a will, then we just follow it.
Yes. If there's a valid will, then you follow the intent of the drafter of the will, which is the subject of the 2 questions we're going to do in a few minutes. Right. Which isn't always easy either. Sometimes it's difficult to figure out what the intent of the decedent is. All right. Other questions? I'm sorry, Alex. I think I might have cut you off. Did that answer your question?
None of this, like the great grandkids, would even get anything at all if he died before O.
B gets a share because he's the son.
But I thought that the heirs are determined when O dies.
Right.
He was never determined as an heir.
Right, but if you're a grandson, if B1 is a grandson of O, that's an heir. Yeah. The formula is when you die intestate, they look for children and they look to grandchildren, right? There's a very specific formula. So when O dies, see, oh wow, there are these grandkids who are the bloodline of B. We give them their cut. All right, questions. All right, so the next topic, which I think someone might have asked about, is the feetail. Okay? The feetail is something very different. The goal of the feetail is to effectively keep land chained to a specific bloodline. Okay? This doesn't exist anymore. It hasn't existed in a very long time, which is why I don't think it's particularly important to learn. It exists in a couple states in a very weak form, although if someone so chooses, they can basically destroy the feetail and make it into a fee simple. Okay? The feetail, the way it works is it keeps it to the heirs of a body. Right? Someone asked about that. This was meant as a way for feudalism to maintain these very wealthy estates. Okay? It's been abolished for almost 200 years. I don't really have anything else to say about it. If you want to talk about it, we can talk about it after class, but it's there. You've heard of it. I'm not going to ask you about it anymore. Okay? Deal? Good? 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 Brandon? Ashley, good? Good. Okay. All right. So let's go back to the life estate, which I teased you with last class very deliberately because I think it made more sense when you did the reading when you were introduced to it in a somewhat sense. Okay? So whenever we're talking about an estate, right? Whenever we're talking about an estate, keep going back to our two questions, right? Who owns it, right? And when do they own it? If you ask yourself these questions over and over again, and you'll be tempted not to, but if you ask yourself these two questions over and over again, you'll be in a much stronger shape to get these because our minds aren't tuned to think fourth dimensionally, right? It's difficult for our mind to think at a given time one piece of property is owned by two different people at different times, right? We don't have DeLoreans, we don't time travel. This is not how we think. So you have to force yourself to think of who owns it and when do they own it. Okay? So the life estate was devised as a way to effectively give land to someone for the rest of their life. But it's a serious restraint on what they can do with it for one very important reason. When you give something to a person for their life, once they're dead, they lose it. They can't really transfer it. Now, they can transfer it. Like, if you have a life estate, you can transfer it, but the second you elapse and assume room temperature, it goes back to the original grantor or goes to someone else, as it may be. So generally speaking, no one wants to buy a life estate. No bank will put a mortgage on a land with a life estate because you can just go kill yourself and the mortgage disappears. Okay? So the life estate has magic words which are very easy to remember. Again, this gets harder, but these are easy enough to memorize, and please do. So something like this, the A for life. Okay? So what are our two questions? Who owns it? A. How do they own it? For life. Okay, this one's pretty easy. Okay? The trickier part is who gets it afterwards. So let's be more precise. O to A for life. If I write something like this, from O to A for life, right? O is the grantor, he's giving the land. A is the grantee, he's receiving it, okay? Everyone with me so far? What happens when A dies? Okay. So I want to use very precise words, okay? O has what's called a reversion. Let me write like this. Let's identify the interests in this question. We already said that A has a present life estate. Right? Who owns it? A. When does he own it? Now. Okay? It's a life estate. How do we characterize O's interest here? Okay? O's interest is not a present interest, it's future interest. And the precise phrase to use is called a reversion. Okay, a reversion. Now, I want you to use very precise words. I want you to say reversion. I don't want you to say revert. The reason why is because revert means something else which you haven't learned yet. There's a reverter, which is something totally different. So say he has a reversion. Only in a crazy system like property law is reversion and revert are different things, but they're very different things. Trust me on this. You'll make this mistake like in a week. So just say reversion. Reversion means it goes back. So A has it for its natural life. When A dies, there's a reversion back to O. Okay? And then, what is O's estate? So let me ask like this, right? Ravi, when O dies, what's the estate? Yeah, how would we, I'm sorry, when A dies, what's O's estate? No, one at a time, Ravi?
Yeah, whatever reverts back to
That's right. I know it's exciting, but try to like not call it answers so people can decide, right? So when A dies, right, O will have a fee simple. Why? Think about it in terms of the bundle of sticks, right? A has a life estate. O has this future interest reversion, right? Once A dies, all the sticks come back together, and O has the entire bundle. He has fee simple. He has it forever for his heirs.
Okay, so before all this, O gave A the life estate. So then everything goes back to O.
Exactly.
Okay.
He gets everything back. But what's important to remember is even while A was alive, O had this future interest. He had this thing called a reversion, right? It's kind of lurking in the background, kind of just hanging out, kind of morbid, waiting for the guy to die, right? And the second the guy dies, he gets back his stick. Now he owns in fee simple. Everyone see this? So this is called a reversion. Add this to your list of notes because we're going to keep adding terms like this, and it's going to get really difficult to keep them straight. So put reversion on your list. Okay? Questions?
Oh, I'm not getting ahead. Are you about to go do it? Are you about to say when O dies?
Sure. Sure. What happened? Yeah, I mean, I wasn't going to, but sure, why not? What happens when O dies? Who's heirs?
O's heirs.
Exactly. Okay. Yeah. Yeah. O has fee simple, right? So I mean, this is effectively O and his heirs, right? At that point. Everyone with me so far? Yes.
So if O dies before A dies.
Ah, okay. Let's try that one, right? Okay. Let's say O dies, and then A dies, right? Is that your question?
Yes.
Okay. What do you think happens there?
Would it be that revert back to O's heirs?
Don't say revert. Reversion. Trust me on this one. This is a reverter, and it's a totally different thing. So yes. So if O dies and A dies, right? Then Blackacre, right? There's a reversion to O's heirs. Whoever O's heirs are. I mean, you can imagine you give a life estate to a newborn baby. The baby lives for 100 years. He outlives O, outlives O's son, outlives O's grandson. And then O's great-grandson is left to find this land, which never even knew that probably.
Okay.
Yeah.
So if O is a grantor, do we just go with the assumption that he has
Fee simple. Yes. Yes. What's going to make it difficult, if you use any other outlines or guidebooks, is they often don't put this. Right. I'm sorry. They sometimes omit this part. They might just say to A for life. I'm doing this now as a courtesy to help you follow it, but often they'll just say to A for life. You have to assume there's an original grantor who had fee simple. That's a safe assumption to make. Right? Now, you might imagine that, you know, from O to A for life, and then from A to B for life. Right? In that case, you know A doesn't have fee simple. A only has a life estate. Right? So try this one, right? So you go, try this. So you go from O to A for life, and then from A to B for life. Right? And these are the sequence, right? These two come right after the other. You know that A only has a life estate. Right? A is not getting fee simple. Yeah.
So when A dies, he has to give it back to O.
Okay. So let's try this, right? So first, okay, at this point now, B has. Let me ask you a question. I'll keep going around the room. So, Gary, let's talk. Okay, so this is the example. These two, right? What is O's estate? How would we describe O's estate? O. Oh. No. What are the two questions I want you to answer? All right, you gotta get, okay. Summer, how would we describe O's estate here? What are the two questions? I mean, talk it out. I'm sorry, say it again?
I was going to say.
No, Rhiannon. Yes, okay, so be very precise, right? Does O have any present interest? The answer is no. O only has a future interest, right? Right? And when does O's interest kick in? When A dies, right? So O has what we call a future reversion. Okay? Everyone with me so far? Harry, you see that?
No.
Why don't you see? Which part don't you see?
We're starting from where it says from O to A for a while.
Yeah, right here. Yeah, so we're talking about O's interest. O started off with fee simple. He chopped up his fee simple, and he gave a life estate to A. But O retains this reversion for the future.
I thought you were asking when he started off with.
I'm asking here with these two transactions. Of course, O started off with a fee simple. I'm asking after these were done. Was that the confusion? Okay. So yeah. So up here, if you want to say at time 0, right? O has fee simple. That's simple. That's simple enough. I'm asking after these two transactions. So the answer is O has a future reversion. Everyone, yeah.
I was just going to ask, in the a future interest by comparison to future reversion, is there anything that sets the two apart as far as?
There are many types of future interests. We're going to cover a lot of them. The one we just talked about is future reversion. But there's going to be a bunch of them. So stop me. Okay, everyone see this? Yeah.
Okay, so from O to A for life, and then from A to B for life.
I didn't get to A yet. I'm walking through this one. Okay, so we have O. Okay. Ashley, what is A's interest here? How would we describe A's estate? That's right. Right. A has a present life estate. Right. Okay. A has a present life estate. Everyone see that? It's at the present moment. He was given this life estate. Okay. Now we see that A gives it to B. Right. This one's a little trickier, and it's mentioned in the notes. I don't know if anyone caught up on it. Troy, how would we describe B's life estate? I'm sorry, damn it. Actually, I didn't give the full answer. How would you describe B's estate? What estate does B have? Well, we're already here, right? B's already gotten it from A. But how would we describe B's estate? Let's talk about it in words, right? Say A lives to be 75, right? And he dies at the age of 75. B's still in the land when A dies. What happens to the land then? Whose life is the measuring life here, A or B? Okay, good. So here's the tricky thing about life estates. Once O gave it to A, right? A's life became the measuring life. In other words, this interest only exists so long as A is alive. Even if B lives to be much older than A, it doesn't matter. So B, I'll give you some French, that's what it means. B has what's called a present life estate pour, I'm going to spell it wrong, atra V. I'm spelling it wrong, but I don't really care about the French. We're in Texas here, right? It basically means measured by the life of A, right? So B keeps it as long as A is alive. This is why no one likes buying life estates, because you have to actually only own it so long as someone else is alive. Yeah?
If O was granting A a life estate and then B a life estate, would that be written out as from O to A for life, then
To B for life?
We're going to do concurrent estates in like a month. This is not concurrent. This is not a concurrent. This is one transaction, right? Yeah. This happens in January. This happens in February, right? They're two separate transactions. You can do from O to A and B for life. You can do that, but we're going to do that later in the semester. That gets different level of complexity. I wouldn't see that. Even though B has a life estate, it's still measured by A's life. B keeps it so long as A is alive. Once A dies, there's a reversion back to O. I see lots of nodding heads, which is good. Anyone doesn't get that, please raise your hand. Yeah, please. Yeah. Sure. A has a life estate. That's the measuring life. B has a life estate measured by A's life. Once A dies, there's a reversion back to O.
So then, technically speaking, O could give B the same estate for life after A dies, if O's alive.
Yeah, I mean, B can give whatever. I mean, O can give whatever he wants. He's the original grantor, right? Because once O gets his reversion back, he owns it in fee simple, and he can then sell it to B or whatever he wants to do. In the back.
Let's say that B died before A goes.
Okay. If B dies before A, it would actually go back to A for the rest of A's life, and then A, yeah, it goes back to O. Yeah, it's kind of a weird thought. Yeah.
So how does B get it from A?
I'm sorry?
I don't know how B would get it from A if when A dies, that doesn't trigger B getting it. It makes
when A dies, it goes back to O.
So I'm curious how B would get it from A.
No, from this transaction.
So while A is still alive,
yes, while A is still alive, you can sell it. There's nothing wrong with it.
B just has just for B's life
yes.
and A's life.
Yes. Yeah. If you have a life estate, you can sell it to anyone stupid enough to buy it. But they only hold it for so long as that the seller is alive. One at a time. One at a time. Yeah. Okay, so the short answer is not so much. Life estates are very rare because they're so violent, right? Once someone dies, everything shoots back to the original grantor. Now, the book discusses something called trusts, which is what mostly happens. So the way a trust works, and this is a predominant way you handle this, is say you have some piece of property and you want to leave it to someone, and you don't trust them to manage it well. You effectively give a life estate to a trustee. This is a person who can administer it on behalf of the person, and they have a fiduciary duty to give them income, to give them rents, or to give them benefits from it. So if you don't trust a person to manage land, and let's be precise, you give someone life estate because you don't trust them. You don't trust what they're going to do with it, right? If you trust them, you give them fee simple. So if you don't trust them with it, you can create a trust, appoint a third party to manage it, give them rents from it, give them whatever money, and they can do whatever they want. They can sell it. So the short answer is life estates are very rare. But as we'll see in the cases today, when you have lots of old instruments that were created very long ago, they do come up. Okay, even that painting case we did last week. Remember the father gave the painting to his son? That was a life estate. So it does happen, but usually when they make a bad planning decision. Yeah.
You said that if B dies before A goes.
Yeah.
It goes back to A, but with B goes.
Doesn't matter.
Because the book said that it goes to Heirs.
If B only, I don't know. I made this example up, so I don't think it's in the book. If B has, well.
It's the same example of an A gives a life estate to B. B dies, that it goes to B's heirs.
Yeah, I guess. I mean that's also. Yeah, I think that might also work. Because generally with a life estate, once you die, you lose it. I think I can see it going either ways. If the lesson you're getting is the stuff is unclear from today's class, it often is somewhat ambiguous as to how this stuff goes. And that's why the intestacy statutes might actually play into that as well. I'm not sure. But that also makes sense. Let's try one other example to teach a different concept, okay? You see, This topic is fun because once you get to the intestates, you have all these different possibilities. Let's try one more option, right? You know, from O to A for life, then to B and his heirs. Okay? So this is a slightly different situation, right? The difference here is that after A's death, someone else gets it in fee simple. Okay? Here, O, right, does not have reversion. But B and his heirs. Ah.
Oh, look at you.
Yeah, tricky. Everyone has heirs. See, Lawson loves saying people have no heirs. Assume that everyone has heirs. I mean, if they, that's why. See, this happens every single time with teachers. People say, "Why do they know heirs?" They're trying to gotcha, right? Everyone has heirs. Just assume that everyone has heirs, right? O does not have reversion, right? A has again a present life estate, okay, and B has what's called a future fee simple, but the estate's actually called a remainder. See? Remainder in fee simple, if you want to be really precise. Exactly. Right, the superhero, like remainder man, right? B has a future interest in fee simple remainder. Okay? Remainder being like what's left over. Okay? This one gets trickier because now you have the reversion and you have the remainder. It's like, how am I going to tell those apart? Okay, so the one way to remember is the reversion is for the grantor, and the remainder is from some third party. Okay, that's one way of remembering it. It's not bulletproof, but that might help you. The remainder comes after the life estate and goes to a third party. Yeah. So try to keep these terms. And again, put in your list. So we've already done. We've done fee simple, right? Fee simple means, you know, I'm going to start this list now, but it's going to get long, right? By next week, we're going to have a table with like 6 rows. So I'm going to try and keep this as simple as I can. So right. So fee simple is and its heirs, right? We've done life estate, which is, you know, for life. Okay, we've done the term reversion. Okay, the term reversion refers to a future interest in the grantor. Okay, we've done also the term remainder. Remainder refers to the future interest in a third party. Study these terms because it gets worse. There are going to be a lot. I don't mean this to scare you or to be mean, but these phrases are not intuitive, and there's just going to be some memorization you have to do. There's really no way around it. Okay? So we've now done 4 of these words which describe different types of estates. And as you saw above, you can mix and match. You can have a reversion in fee simple. You can have a remainder in fee simple. You can have a remainder in life estate. You can have a reversion in life estate. So you have your present and you have your future interests. All right, everyone with me so far?
A reversion in life estate would look like from O to A for life, then to O for O's life.
Okay, so let's go back to the example here, and I think the book had a slightly different explanation. So let's say, where was it, right? This one right here, right? From O to A for life, and from A to B for life, right? Technically, if you'll be really precise, A has a reversion in life estate.
Because A is the grantor, so one.
Yes. So with this second transaction, really hyper-technically, right? A would have a reversion in life estate because when B dies, and I think the book has a different explanation, but one way of looking at it is when B dies, it goes back to A A has it for the rest of his natural life. So A would actually have a reversion in life estate. Gets really, really messy. Yeah.
How specific do you want us to get?
Yeah. You'll see in some of the sample exams that the questions I ask. That's probably the ballpark of where I want to go. And this is no surprise. You can go download my exams, but there can be some really complicated conveyances with like maybe 3 or 4 steps, and each will happen on a certain date. I'll say, at this date, right, what are the interests of O, A, and B? On this date, what are the interests of O, A, and B? And I want to walk you through the thought process, and this is for your benefit because it's very annoying to give you a single factor and say, okay, at the end of the day, who owns what, right? So at least if you walk through day by day, step by step, here I have 2. I might have 5 or 6 of these, right? And at each date, what are the interests of A, B, and C? What are the interests of O, A, and B, right? That is how you test this really annoying concept. Other questions? Other questions? All right, let's do the case. You're comfortable with cases, right? Case is a little. It's like you're actually relieved to do a case. So let's do Adriana, let's do the white v brown white v brown case. Okay. What happened here? What was the dilemma?
We have a widow, and she has children, and she had a will, and in there she left her house to some relatives, and she was one of the nieces of the of the will.
Good.
She got family members saying that she made a life estate, and the other side saying no, she made a
Okay, good. All right, so we have this case where someone wrote what's called a holographic will. Now, I know that sounds really cool and awesome, right? It's like, something from like Star Trek, right? A holographic will means written by hand with a pen. It's like the most underwhelming term in law. I was so disappointed when I first found out what that word meant. All it means is a will written by hand. Presumably the person was old, they didn't have access to a lawyer, they didn't have any money, whatever, so they drafted their own will. This case is a reason why people should not draft their own wills, because it's very difficult to try to figure out what a person intends from these words. Now, if you notice, she didn't use our magic word. She didn't say, Evelyn White has a life estate. That would have been too easy, right? She didn't say Evelyn White has fee simple, right? That would have been way too easy for us to manage. So instead, we have this. So everyone can see this. I blew it up nice and big. It says, I, Jesse, being in sound mind, blah, 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 appoint Sandra White to be the executrix. Executrix is the female version of executor. And I first heard the word litigatrix has an interesting provenance, because at one point that's how you refer to a female litigator, but that term dropped out of use. But now it actually has a somewhat pejorative connotation because it's almost of a blend with dominatrix. And it's used in this is a debate in legal language. It's actually used almost to describe a very aggressive female litigator. So there's actually some debate about this word. It's called litigatrix. But we'll stay here. Yeah.
Okay, so on the syllabus, I don't understand where we're getting this case, because it's not. I can't find it.
I think I made a typo which I changed subsequently. But yeah, it's on page. I mean, it's right after the case that came afterwards. It's on page. Yeah, I mean, it's there.
Oh, okay.
And in the event that the page numbers are wrong, there's an index in the book, and you can look up the case in the index. Yeah.
I see.
Yeah, so 227. So yeah, in the event you're confused about the reading, just I list the case names there as well, because double redundancy, so you can look and index the book. All right? So we have this will, and it says, okay, so Miss Sandra Perry will be the executrix of my will. Okay? So here we have this sentence. I wish Evelyn White to have my home to live in and not be sold. Okay? Then it says, I leave all my personal property to Sandra White Perry. And again she says, My house is not to be sold. All right? Everyone get the gist. All right, so Samantha, forget about property law for a minute. Like, pretend you've never come to this class before. Pretend you're someone who has no knowledge of property law, and your grandmother, writes a note like this, right? What do you think your grandmother's wishes are when she writes a note like this? Yeah. What do you think your wife intended with respect to Evelyn White? Just based on this, and you know nothing about law. Okay. For how long? I mean, does anyone live forever?
No.
Right. Okay. So one way of looking at this is saying that Evelyn can live there, right, for the rest of her life. And then it goes to your kids? Could your kids sell it? So no one can ever sell this house ever. Okay. Cassandra, what do you think? Again, you've never gone to law school. You don't know anything about life estates or any of that stuff. How would you read this if you were, a layman looking at this for the first time?
Well, I think that Evelyn, she's a
Uh-huh.
and for Sandra,
Okay. And what happens when Evelyn dies?
and Sandra has it.
Sandra has it. Okay, interesting. All right. So here's the difficulty, right? We have two reasonably intelligent people who have legal training, and they look at the exact same will, right? Totally differently, right? So how do we figure out what she intended? And I think there's a couple ways of looking at this, right? If it says, I wish Evelyn to have my house to live in, right? One way of looking at that is she can live in there for how long? Well, presumably the rest of her life. So that suggests that there's something about her life that's important. But she also says, and she underlines it, the house is not to be sold. So this isn't just a condition of how long Evelyn can live there. This is also a condition of what can happen to the house. Right? So let's go to the next sentence, right? I leave my personal property to Sandra, right? Is there any limitation on what Sandra can do with that personal property? The answer is no. Sandra can sell it, she can burn it, do whatever she wants with it. So it seems that there's a difference, right? That Jesse knew the difference of how to leave property full, what we might call fee simple, versus leave property with some strings attached to it, which is what she seems to have done here. So the difficulty with this case has to do with how the court goes about reading this will. Okay? So Jacqueline, what does the court do here? How do they go about construing this document?
Well, they first basically say that it's not clear, that the intent is not clear.
Right.
So they're looking at Chapter 33 of the Public Acts and Chapter 180 of the same Act to interpret the words and the context of that will.
Uh-huh.
And they look at those laws, and then they look at different case laws, Green, Williams, and Webb. And I think basically they say that it all goes down to their interpretation of the words not to be sold.
Okay, good. And in the end, what does the court hold? At the very end.
They say we conclude Ms. Lee's will pass as a fee simple absolute in the home to Ms. White.
Okay, good. So you don't really take classes in statutory interpretation or statutory construction, which is unfortunate. You maybe do a little bit in contracts with how to read different contracts, right? But one of the ways that legislatures have been able to deal with these very ambiguous texts is they've passed statutes that say, as a matter of law, we will interpret wills in a certain way. And one of the presumptions that they've imposed is that we'll presume that someone intended to pass a fee simple unless it's otherwise clearly stated, right? We effectively said, we don't like life estates, right? Life estates are very messy. We have to make sure that someone's still alive, and once they die, there's this violent transfer of property to a third party. So because we don't like life estates, we're going to simply presume, unless language is really clear, that they're passing fee simple, right? What's the problem, though, Ashley, with that presumption in this case?
Like what the dissent said?
Sure.
Okay, well, the dissent kind of said it wasn't ambiguous, that by saying, she can live in this house, and I thought that she was given a life estate, and it kind of attacked the cases that the majority used when they were making their decision, saying that one of the cases, the testator also left like all the personal property to the person they left the house to, so that was kind of indicated that it needed to, that it was meant to be simple.
Good.
And I think they were just something like that. But basically, they were saying, by saying she can live here, she can't sell it, she intended to make a life estate.
Very good. You have another comment?
Yeah, I was going to say that she also said that the fact that Mrs. Lyde made a gift of a personal property without limitation, that she knew how to deal with an effective limitation on that, as an indication that there was to be some kind of restriction on the house.
Good. Good. Okay. So let's look at this very clearly, right? The majority says we're going to follow the statutory presumption, and because the text isn't clear, we're going to presume that she intended to only pass a fee simple, right? This has to really strain credulity, right? And I think as Cassandra and Samantha said, the text is actually pretty clear what she wanted, right? Very clear, she said, Evelyn can have my house to live in, right? Live in means you're alive, right? You live as long as you're alive. I don't mean to be pedantic, but that means a life estate. This is how a non-lawyer would say life estate. You can have it to live in while you're alive. When you're no longer alive, you don't have an interest in it. And as if to make it really clear, it's a life estate with strings placed on it. You cannot sell it. She didn't say that once. She said it twice. You can't sell it. Is that consistent with a fee simple? No. The entire essence of a fee simple is that you own it free and clear, and you can do whatever you want with it. You can leave it to your heirs, you can sell it, do whatever you want. So the majority opinion effectively has to cross out like 8 words from the will, right? To, I wish Evelyn to have my house, home, right? And then they cross out the rest of the sentence, right? They effectively have to cross out the last, 6 words or 2, 4, whatever the last 8 words of the sentence. This is, I know it sounds crazy talking here, but this is what judges have to do when they have to interpret wills drafted by non-lawyers, or even, true enough, wills drafted by lawyers who are not very good. Those exist as well. We shouldn't put all the blame on people drafting their cool holographic wills. Lots of lawyers mess up all the time, right? So they effectively have to rewrite the instrument. Okay, is your hand up? Also, it really requires striking out this other part, right? Because Jessie, in her non-legal terms, was very aware of how to leave property to someone in fee simple, right? When she says, I leave my personal property to Sandra, she's giving it to her in fee simple. Sandra can sell it, give it away, leave it to her heirs, whatever she wants. So the majority opinion has to really, close their eyes as to what Jessie intended. And I think the reason they do this is because they want to minimize the number of life estates, right? Life estates are very aggressive, they're hard to police, there's a lot of change and volatility, and the law tends to like certainty, right? The dissenting opinion makes it very clear of what she intended, right? You live in it, it's a life estate. So this is a case where the majority probably gets it wrong, or maybe close to being wrong, because they want to promote certainty. And so what's the effect of this decision is that in other cases where you have similarly vague instruments, where it's unclear if it's a life estate or a fee simple, the probate court will err on the side of making this fee simple. Okay? All right, questions on that case? All right. And it's funny, they said afterwards, Miss White eventually had a stroke and she died, and the house was eventually sold anyway. So Jessie's wishes were not held by. One point which they mention in the notes afterwards refers to what are called restraints on alienation, right? Alienation, which you've was a TV show in the 80s, which probably no one remembers, a couple of people. But alienation has to do with the word like alien, which means to transfer. Okay? Alienate. Can't spell. Generally speaking, the law presumes that land is alienable. And something called a presumption of alienability. What's a presumption of alienability? It means we presume that land can be transferred. We don't like when limitations are placed on who can transfer land because it puts land to a bad use, right? It's a very bad idea when a person who owns a piece of land can't sell it, right? Think back to the Indians in our very first day of class, how they owned a piece of land. They could be on it, but they couldn't really sell it. What Jessie tried doing here was she actually tried creating a life estate with restraint and alienation. She basically said, you have a life estate, but you can't sell it. Generally speaking, when you have a life estate, you can sell it. I mean, it's not a very smart transaction for the buyer, but you're free to sell it. So Jessie, on top of everything else, made a life estate with the restraints and alienability. I think what was actually going on here was the court didn't want that, right? The court would be much more comfortable with a fee simple than having what we can call a life estate with a restraint on alienability. Okay. Everyone see that? And there's some notes afterwards which aren't too important, but they discuss why we want to encourage alienability, right? Because when land can be sold, it can be transferred, it can be improved, people can put it to better uses, they may be able to build upon it, and it doesn't make much sense to force someone to keep a piece of land. Also, if a person owns a piece of land they can't sell, it's not very valuable to them because they can't really do what they want with it. Maybe they want to move, do something else, build another piece of land. So generally, land has this. Okay, provenance. Ooh, it's a good word. I like provenance. All right, that case gave me a headache. Sure, me too. All right, questions. Any questions on this case? Yes, sir.
We need to know the 3 types of restraints.
No. Don't worry about it. Other questions? Okay. Yeah, there's that reading which I asked you to skip on the valuation of the life estates. Don't worry about that at all. It's more complicated than it's worth. All right, let's go on to Baker versus Weedon. Allison, what happened in Baker versus Weedon?
Well, it first starts off with John Weedon, and he first married Lula Edwards and had 2 daughters with her, and then they, one of them had 3 kids, and the 3 kids, so his grandchildren, they're the plaintiffs in this case, and then he divorced her, and then quite a few years later, John married Anna, and she was much younger than him, and they didn't have any children together, and in John's will, he left everything to his second wife, Anna, and then, except for a little part that he gave to the grandchildren, which they would share equally. And so Anna ended up living somewhere else, and she had some financial troubles, and so she wanted to sell a piece of the land when it came up for sale in Mississippi. And so the whole issue is the grandkids don't want to sell the land because they would take a financial hit. Okay, good. All right, so this case is interesting, right? The facts of this case are very interesting because basically the woman outlives everyone. It's crazy. So you have this old guy who was in his 50s, and he marries a woman who's 17 years old, okay? And, there's significant difference in age. He is all up in age, and he decides to leave this farm to Anna Plaxco Weedon, okay? But what's not written here is that he doesn't trust her, right? How do we know he doesn't trust her? Okay. If he trusted her, he would have just given it to her in fee simple, right? If he really loved his beloved wife, he'd give it to her in fee simple. But that wasn't his intent. He actually wanted this land to go to his grandchildren, who he had not much of a relationship with, but he had some kinship with them. The parents were a bunch of ingrates, right? He didn't care about them. They only asked him for money. So he wanted something to go to his grandparents. So he's thinking, okay, how do I make sure that my wife is taken care of, but the grandkids get it eventually? So he could have said to my wife, sweetie,
I'm going to give this to you in fee simple, and I hope that you take care of my grandchildren when I die. Everyone shaking their head no. There's no guarantee that happens, because once you're dead, you can't do anything about it. So the purpose of these kind of property grants is to literally control land from a dead hand. Long after you're gone, your wishes continue to be fulfilled. So how did they do this? They gave, so it says, I give to my beloved wife. Oh, he definitely loves her, right? And it said they had a compatible relationship, no children for whatever reason. So I give all my property, both real and personal, during my natural life. During, keywords, during her natural life. Okay? So this is effectively giving the wife a life estate. Okay? The wife only has a life estate. Okay? And there's not a reversion here, right? Brian, who has, let's put together what we just learned, who has the future interest here? Okay, well, whose grandchildren? Let's be very precise. Go read it, left to right. Go one clause at a time. So at first we say, during her natural life, right? And then what comes next?
To Mr. Weedon, is that his name? Mr. Weedon's grandchildren?
No, before we get to the grandchildren. Look, it says, during her natural life, and who gets it next? Her children, Anna's children, right? Everyone see that? When Anna dies, it goes to Anna's children, if she has any, right? Brian, what do we call the interest of Anna's children? What do we call that? We'll only do a couple words. It gets harder after this. What do you call the future interest after a life estate?
The future interest after a life estate. I'm not sure.
Remainder. We did that term 5 minutes ago, right? Remainder. The kiddies have a future interest in remainder. And it really be probably remainder in fee simple, right? So if Anna actually had any other children, those children would get it in fee simple. And we do know from the facts that Anna did get married another time. No children were born, and she seemed to have outlived that husband as well. So maybe, whatever, no kids. All right. So if the event that Anna dies with that issue, there's no kids, then at the death of my wife Anna, classically, I give, bequeath, blah, blah, all my property to my grandchildren, each sharing equally. That's per stirpius, right? Each sharing equally. Okay? So let's see. Christian, how would you describe, then, the interest of the grandchildren? How would we describe that? What's their estate? How would we describe it? Well, let's start from very simple. Is this a present interest or future interest? Okay. And what specific type of interest they have in the future? Well, you said it's fee simple, but is it guaranteed to be a fee simple? Why not? In what situation will the grandchildren take nothing? What has happened? Yes, okay. So in order for the grandchildren to take, right, Anna has to die and have no children, right? So what happens if Anna has children? The grandkids get 0, right? Okay. So how would we describe, then, what's left over for Anna's children? What would we call that? Remainder. Okay? So here's what happens. We have 2 sets of remainders, right? Anna's children, if they exist or not, have a remainder. Okay? The grandchildren also have a remainder. Right? You can have multiple layers of remainders stacked on. So let me get 3 markers if I have that many, right? All right, then there's a marker. So in the one hand, right, Anna has a life estate, right? Her children have a remainder, and the grandchildren have another remainder, in that order. So if Anna dies, right, and there's no children, then the grandchildren take everything, right? If Anna dies and there are children, then the children take everything. The way they stack these is to anticipate all the different eventualities that may happen.
Why is this not exactly not a reversion for the grandchildren specifically? Because I mean, it would go back to O's line.
Who are O's heirs?
Oh.
Oh, right. O, read the next sentence. I am specifically excluding O's children. Ah.
Okay, so that's not a reversion because
It could be, right? So,
go to the children.
right, yeah. So say like this. Let me say and lose example for a second, right? I'll get to you in a moment. Pretend we got this out, right? It said I give it to Anna for life, and then to Anna's children if she has any, right? If Anna has no children, it will be actually reversion back to the husband, and the husband's heirs would get it. And then it will go to the ingrate children. Right. Is there a question there? We're going to do that in a few weeks, so don't worry about that yet. Preview the things called vested and contingent remainders to make it even more complicated. You'll get there in a few weeks, but we will describe the different natures of remainders.
Question: Is Anna having kids out of wedlock? This guy, forget his name.
The original husband.
The
Yeah.
original husband.
Yeah.
Do those kids have a superior right to become the first remainder?
Okay, so the phrase used back then, and I don't like the phrase, was actually bastard children, right? That's not the phrase we use today. The other phrase is illegitimate children, which is a phrase we also don't use, and then use the nice word children out of wedlock. At that time, I think this was in Mississippi, that probably would have made a difference. If you were an illegitimate child and you were not recognized by your father, you're not an heir. That's not the law today anymore. Not quite. But for a long time, if you're an illegitimate child, you couldn't take anything. Now there are different ways of paternity tests and going Maury-Povich and things of that nature to prove who the daddy is. So I don't think that would fly today. I don't think it matters if they're legitimate.
That he recognized them.
Yeah.
Who would have more influence or remainder?
Well, if the children are recognized, then their issue. I mean, they're children like any other.
So that they will become kind of like an adopted child, and therefore.
Adopted children, it gets a little messy because in some states, adopted children are considered blood, and in some states they're not. So that does get a little messy. This is why you should have a will. If you have a will, you can designate. See here, what's interesting is he said grandchild, right? He named specific, each of the specific grandchildren, right? Actually, he didn't name them. So what would have happened? Actually, could there be more grandchildren born? I don't know. What if one of these ingrained children have another grandkid, right? What if there was a third or fourth grandkid? Then they would also split it. He didn't name specific people. He did name the ingrate children who wanted to take nothing. That he was very clear about. So really, he left this class of grandchildren to perhaps open up, and the class could expand as more people are born. Questions? What makes this case really difficult is that the father, the original father, tried to control with great specificity who would get the land and when. Okay? So in the end, though, it was only a life estate, right? Anna only a life estate. The perverse part is that she outlived just about everyone, right? And where it gets very sad is Anna was basically broke. She didn't have any money. She couldn't afford to live on the land, right? So she was in this rough spot. She wanted to sell the land, but no one's going to buy it just from her because she only has a life estate. And once this woman dies, she lived to the age of 98. She outlived everyone, right? But once she dies, it would then jump over to the grandchildren, right? So the correct way of actually selling this land, right, the sensible way, would have been for the grandchildren to join together with their dear grandma, I guess, right, and say, all right, we're going to sell this together, right? You have one stick, we have the other. If you sell it in the same transaction, it becomes fee simple, right? They could have united their interests, sold it in fee simple, and then anyone could have bought it. The reason why they didn't do this was because they've lost money like that. There was like an interstate being built, and the highway was coming close, and they anticipated at some point in the future the land would be worth a lot more money, right? So they didn't want to sell it now. So they were effectively waiting for Grandma to die. As morbid as that sounds, they're waiting for Grandma to die so they could sell at the highest possible price. Because that way they don't have to cut it. They don't have to cut her in on the deal, right? If they wait for her to die, they split it 3 ways. If they do it now, they split it 4 ways at a lower premium. So they were basically waiting for her to die to sell the land at a higher value. So the actual nature of this case was a lower court judge forced a sale, right? He forced a sale of the land, saying it's not fair that, you know, Anna is stuck on this property and can't sell it for anything else. And the Court of Appeals basically reversed, saying, listen, the original grantor gave her a life estate. That's what he intended to do. And just because she's not getting enough money from it doesn't mean we can't dissolve it, right? We can't change the way people decide to get property because it's not fair. We have to bind people to what the instrument says. So the court says, no. If these kids really have sympathy for Grandma, they can sell the land now, or they can make her pay some of the rent or something. But you can't force the sale. Okay. And at the very end, of course, what's funny is she outlived all of them, and she lived to the age of 98, and she was still on the land in a wheelchair. She sounded like a really tough woman, pretty impressive. She lived through some really hard times, and then she survived. All right. Any other questions on this case? All right. Have a wonderful day. I will see all of you next time.
Dude. So the company that does tours in Dallas just runs out of